Okay, so this is for the first Shlomo for all the Cholim of Klal Israel and for the protection of all the security forces, armed forces, military people protecting the country and the Jewish people. Protest, this is a short one only. Protesting a non-Jew's malacha on Shabbos. Even in a case where a non-Jew may work for a Jew for free, if the Jew finds him working on Shabbos, even if he's doing the work in the privacy of his own home, the Jew must protest. However, in case of a true kablanus, which is a contractor, like a person doing construction, etc., wherein the non-Jew is assured of even an unspecified sum, one need not protest because they can do it in their own time. Okay, so secondly, in a case where paid non-Jew may work on Shabbos, for example, if he is given the job long before Shabbos, if one finds him working on Shabbos, some hold that his employer need not protest. If a Jewish employer hears that an employee hired during the week, if the Jew told or even hinted to the non-Jew that he needs, oh wait a minute, that's something else. I don't know, it's gone to the wrong page here. Sorry, there's this format here. It's okay. If a Jewish employee hears that an employee hired during the week as a sachir is working for him on Shabbos, even in private, he must go to the employee to protest. And lastly, if a Jewish shoemaker is commissioned to make shoes if a non-Jewish shoemaker is commissioned to make shoes for a Jew with his own materials, and the Jew finds him working on Shabbos, he need not protest, since the non-Jew can decide to give these shoes to someone else and make a different pair for the Jew. He is not considered to be working for the Jew with his own materials. So that's the non-Jew, not the Jew. Okay. Okay. Anyway.
All right. Okay. Thanks, Ken. Okay, Arth, you want to mute yourself, mate? Okay. All right. In the preceding Gemara, Rava interpreted the Brice's first case as dealing with three sets of witnesses. The first set that testified that the master first destroyed the slave's tooth and then his eye. The second set that said that the reverse happened, that the eye was destroyed and then the tooth. And a third set that exposed the second set as Zomamim. So from the Brice's ruling that the second witnesses are liable as Zomamim, even though the testimony was already contradicted by the first set before they were exposed as Zomamim, Rava deduced that if witnesses testified to a murder and were subsequently contradicted, they nonetheless remain subject to hazama at the hands of other witnesses, for contradiction is at the beginning of hazama. So Abaya refuted Rava's reference by interpreting the Brice as dealing with only two sets of witnesses, and now the Gemara questions Rava's inference even from this interpretation that the Brice deals with three sets of witnesses. Rav Acha, the son of Rav Ika, said to Rav Ashi, from where did Rava deduce that contradiction is at the beginning of the Hazamah? If you want to say that the Brice's first case, where according to Rava, the witnesses state that the master is liable to pay for the eye, and the middle witnesses that say is liable to pay only for the tooth, there's no proof from that case, as you remember, because in the Brice's first case, are the middle witnesses contradicted and their testimony is set aside. So that's what it's proposing, and they say not at all, because if they had been rendered conspiring witnesses, the testimony actually accepted by the court would have remained in accordance with them. Well, the reason why we're saying is if the one group says the eye and the other group says the tooth, and the group that says the tooth is the low amount, the court will go with it unless there's evidence proving that the higher amount is in fact the amount that was damaged, because we can only go with what's proven. Both the sets of witnesses agree that the master injured the slave enough to set him free, and therefore there's only a penalty as a free man for what he would have sued either the eye or the tooth. In absence of evidence, we only give according with the low amount, which is the tooth. We don't go halfway in the middle, because it's not fair unless the burden of proof can be proved. So if the law is then set with the second set of witnesses that are wanting the master to pay the lower amount, and basically the second set are caught as Adam Zommerman, where witnesses said they couldn't have seen the event because they were somewhere else, then the reciprocal penalty of what they wanted to do to the master, we do to them. And what did they want to do to the master? They wanted him to pay for the tooth. So what actually happened? That the master had to pay for the tooth. So obviously in that particular case, you don't have to say that Hazamah is at the beginning of the process, because we actually never set aside the middle set of witnesses. The first set of witnesses were set aside because the I was the higher amount and that could not be proven. So if you're looking at the first case of the Brisa, this isn't a case that proves Rabba, where Hazamah is worked from the beginning of the process. So the Gemara obviously reinterprets Rabba's proof. This is where we are at. Rav Ashi said to him, indeed, Rabba did not deduce his rule that contradiction is the beginning of Hazamah from the Brisa's first case. Rather, Rabba holds that since the first case of the Brisa deals with 3 sets of witnesses, we should presume that the latter case of the Brisa also deals with 3 sets of witnesses. And Rabba therefore deduces that contradiction is the beginning of Hazamah from the Brisa's latter case, which according to him deals guys with the following scenario. So there are 2 witnesses that came and said the master first knocked out his tooth and then blinded his eye, and the court issued a verdict on the basis of their testimony. In other words, they awarded the slave his freedom and damages to the eye. And then 2 other witnesses came and said the master first blinded the slave's eye and then knocked out his tooth, which means the ass freed him, and as a free man, the slave sued for the damage to his tooth. So the testimony of the second witnesses caused us to set aside of the first testimony. Why? Because whenever you've got a contradiction of testimonies, you set aside the first testimony. Okay? Now, how do we rule technically? Well, the slave goes free because both parties agree that he was damaged. And then they have to obviously settle if they both agree a second organ was damaged, but they don't know the order, or they're contradicting the order, the lower amount is paid. So if you want to talk about the second case of the Brisa, in that case, you've got a case where the Brisa, in the second case of the Brisa, the first set of witnesses were exposed as Adam Zommerman. So what happens is that they intended to cost the master the value of his eye, of the slave's eye, even though their testimony had already been set aside prior to them being as exposed as Adam Zommerman. So if you're clarifying that in the case, and you say, look, contradiction, if you want to say that contradiction is not at the beginning of Hazamah, the first group and the second group are contradicting each other. The high amount was the first group in the second Brisa's case, which is the I, and if it's contradicted by the low amount, we go with the low amount. So since they contradicted each other, when Adam Zommerman come and exposed the first set of witnesses lying about the eye, you technically can't try them and say, well, they owe the master the fee of the eye instead of the tooth. And Kevin, in that case, obviously all that would be paid, as the Meiri would say, it would be the difference between the eye and the tooth, because the master had already then paid for the lower amount of the tooth, and they sought to extract from him the value of the eye. But we are saying that the reason why Hazamah in the second Brisa's case is at the beginning of the process is that the 2 witnesses should cancel each other out, because the first set of witnesses that are exposed as Adam Zommerman were actually trying to extract the greater amount, and therefore the reciprocal penalty that would apply is exactly what they wanted to do to the master and make him pay for an eye instead of the tooth, and they were exposed as Zommerman. But the problem is, if their testimony was contradicted by the second set of witnesses claiming damage to the tooth, then the 2 should cancel each other out, and then you can't do the reciprocal penalty based on Adam Zommerman of the third set of witnesses. And the Gemara is saying, learn from this that the second case in the Brisa is where you have to say contradiction is considered the beginning of the Hazamah process, according to Rava. Does everybody understand before we go on?
Yeah.
Do you understand the difference between the Bryce?
I understand everything. I can't give it over, but I understand it.
Okay, Kev, do you understand?
Say, what's the contradiction in terms of the testimony for the tooth and the eye?
Yeah, so what we are saying
is that what the contradiction's about?
What we are saying is, in simple language, there's two different Bryces. The first Brycer, the damage for the eye, there's first damage for the tooth and then damage for the eye. So the tooth frees the slave. The slave is a free man, sues the master for the eye, according to the first set of witnesses. According to the second set of witnesses, they're saying the eye was damaged first and then the tooth. And then when the second set of witnesses are exposed as Eidim Zumimim, the court hasn't set aside their testimony, and that's exactly why we don't really apply the reciprocal penalty, because what did they intend to do to the master? Made him pay for the tooth. What did the court case verdict end up like? That you pay for the tooth because it's the low amount anyway. So therefore, there's no need to say that contradiction is at the beginning of Hazamah, because the two witnesses don't cancel each other out, as Gavin knows. It basically went with the verdict of the second set of witnesses because they tried to extract the cheaper amount. And in the absence of evidence, they can't cancel each other out when they both agree that the slave was assaulted. They both agree a second injury took place. They can't agree on the order. Then in that absence, it's not thrown out altogether, because the minimum that they both agree to, Kevin, is the value of the tooth. If I say a more expensive item in the house was damaged, and you say a less expensive, we can both agree that at least the least expensive item was damaged. We actually not disagree. So therefore, the testimony of the second set is enforced in the court verdict. And if they are caught out as Eidim Zomim in the second set of witnesses, and we say, right, you intended the master to pay for the lower fee, we're going to apply the reciprocal penalty, they're going to say, well, what are you talking about? Our testimony wasn't put aside. The first set of witnesses in terms of the higher damage was set aside. And Gavin quite rightly said, if it wasn't for those lying witnesses, the slave would have gained an eye. But then the first set of witnesses should have had a stronger case. That's all we're saying. But the second case of the Bryce is different, Kevin, because the Eidim Zumimim are found on the first set of witnesses, not the second, who are trying to extract the greater amount from the master. And in that case, what would happen is they would cancel each other out because they don't agree with each other, and the court would never go like the more expensive option. So since they don't agree and it cancels each other out because you don't know who to believe, and you want to kind of go with the cheaper testimony and say when you want to apply the Eidim Zumimim for the first set of witnesses, they've already cancelled each other out. You can't say that. You can apply the reciprocal penalty because they both contradict him. Therefore, the witnesses with the eye were invalidated by verdict of the court automatically with the value of the tooth. Since they were invalidated and their testimony wasn't upheld by the court, what they sought to do to the victim was not actually achieved. And therefore, since the court verdict didn't go like they wanted, we cannot apply the reciprocal penalty to them. Unless you say that Hazamah process begins at the beginning of the trial, which goes to prove that even if they're contradicting each other, all this proves is that the first set of witnesses were liars in the beginning. They're still liars. They never cancelled each other out. This is just proving the case stronger. That's all. That's all. But Rava only gets his proof from the second case. So now a buyer, we want to know what his response is. And a buyer would say to you, granted that in the Bryce's first case, it's not sufficient to explain the Bryce's statement if there are not three sets of witnesses. So he's agreed. For the Bryce's states, and indeed the master claims this as well. So what he's saying is, look, if the master is approving of the testimony, it can't be two sets of witnesses because then you're like kind of starting in the middle of the trial. What is the master approving if there's only two sets of witnesses? He's got to be approving of something that could be the lower amount. Now, if you've got two sets of witnesses, it doesn't necessarily mean that he's approving of anything because there's not sufficient time at which he was sought to pay the greater amount. So obviously in the first case, he's saying there's a possibility, not just like I'm saying there's two sets of witnesses. He's still saying that, a buyer, but he's saying it still does work with three sets of witnesses. That's all he's saying. Okay, because you have to do something with the Bryce's line, and indeed this master claims this as well, because the master wants to pay the less amount. But then Abai is saying, well, there's a problem, because there's the other part of the Bryce's last case, which says, why do I need it to say that it deals with 3 sets of witnesses? Is it because the Bryce has stated about this case, and indeed the slave claims this as well? Because just like the master wanted to pay the lower amount, what do you think the slave wants to get?
High amount.
High amount, exactly. So what do you do with that line? So basically, a buyer has to deal with that. The Gemara is asking me, so what do you do with the line? And indeed, the slave wants this as well. How do you say in the second case that there's only 2 sets of witnesses? Because basically, a buyer is saying that 2 sets of witnesses in the first and second case. But he said, I give Rava this much, that if Rava says there are 3 sets in the first case, there's no reason to say that there's not. Because you've got to do something with the line saying, and the master approves this as well, which means what is he approving? There has to be some starting story. But in the second, the Gemara is then asking in the Bible, what about your story with the second case where it says, and the slave approves this as well? There's got to be 3 witnesses there, because how does that story start in the middle? So Abai gives a very decent answer. He said, look, when it says the slave approves, he's not saying that the slave approves in order to get the big amount of the eye. The slave's just happy, Kevin, to go free. That's what Abai is saying. He's saying, obviously, he'd like the higher amount as opposed to the low amount. But let's be honest, if you've been in Alcatraz and you're awarded a small damages action of $100,000 or $200,000, sure, you'd like the $200,000. That's low on your priority list compared to 100. You know what's high on your priority list? Not landing up sexually raped in Alcatraz every night by the moonlight. That's your higher priority. So I'm saying they're priorities. And what he's saying is, as far as the slave's concerned, he would, this master couldn't have been such a nice guy, because he's obviously got a pattern of abuse, both physical and verbal. He's only too happy to get out of his clutches. So what Abai is saying makes sense, is that yes, he likes a high amount for the eye, but that's irrelevant, because whatever witnesses would have said to get him out of the situation, he would have said, yes, they're right. He just wanted his freedom. And I think Abai is making a good point here. That, as far as the slave is concerned. Does that make sense? Now, the master, if you look at how a buyer could say that there are 2 witnesses there, I mean, what is the master proving? Well, firstly, the master's losing his slave either way. He knows that now because of the contradicting witnesses. What he wants to get out with is paying the least amount of damage. His priorities are very different. So it says, the slave will say whatever the sequence of injuries reported by the witnesses are. Why? Because he is satisfied to go free. Thus, the statement can be explained without resorting to 3 sets of witnesses, and there's therefore no reason to give a forced interpretation of the Bryce's second case and involving a 3rd set of witnesses for the Bryce. Okay? Accordingly, there's no proof from this case that contradiction as at the beginning of Hazamah. Because again, if you look at it, a buyer just needs 2 sets. What it has is the first set is saying that you owe for the tooth and then the eye, which means you owe for the eye. The master hit the tooth first, making the slave free. The slave is a free man, is now suing for the damages of his eye, which is the greater amount. Okay? And then the second set of witnesses come along and turn around and say, listen, the first group are saying the incident happened on the Monday. Okay, they couldn't have seen the incident on the Monday because they were with us at Eastgate. What actually happened is they heard us talking about this horrific case through friends of ours, and the case occurred on the Sunday, but the eye was damaged first, freeing the slave, and then the master hit the tooth, which allowed, as a free man, the slave to sue for the value of the tooth. So the Hazamah process, proving they weren't at that location on Monday, as well as them saying the reversal order is enough that you only need 2 sets of witnesses. And secondly, what's happening is the false witnesses are said to have occurred the incident the day after the incident happened, because if they said it a day before, they'd be responsible to the master, not only to pay the value of the eye that they sought to claim from him for the slave, but also for the slave's freedom, because at the time, the master didn't hit the slave, so that was technically conspiring event. After the drama happened, you can say that a later incident happened, because at that point the slave was already set to go free, date-wise. But if you invent a case before the actual issue, then you're accusing somebody falsely of assault or murder, whatever it is you want to accuse them of, before something transpired. You're only not Adam Zimmerman on that account, not for the damages, but for the freeing of the slave to the master, if the incident had already transpired. It makes sense, it's pretty straightforward. So the Gemara now goes on a bit of a digression, and it says, look, it wants to analyze the premise of what the brass is based on. So it says, okay, so the brass is taking for granted that when a master destroys two organs of the slave, like the eye and the tooth, he must set him free on account of the first and pay damages for the second. So the Gemara is questioning, is this ruling correct? Rav Zari objected. He said, let us say that a master blinded his slave's eye. Okay. He should go free on account of his eye. And if he knocked out his tooth, he should go free on account of his tooth. So what he's saying is, if you look at Shmot, chapter 21, verse 26 to 27 in Exodus, it says, if a man strikes the eye of his slave or the eye of his slave woman and destroys it, he shall set him free in the place of his eye. And if he knocks out the tooth of his slave or the tooth of his slave woman, he shall set him free in place of his tooth. So it's evident from the verse, guys, that destroying even one of the organs sets the slave free. Okay? So basically, what's happening is, and if he blinded his eye and knocked out his tooth, he should go free on account of his eye or tooth. So what Rav Zari is saying is, okay, granted that destroying even one of those organs renders the slave a free person, but it can still be argued that destroying even two of them entitles the slave to nothing more than his freedom. That's Rashi's explanation of Rav Zari. So why does the Brisa assume otherwise? So basically, this is answered by a buyer who said, look, if you want to read the verse, it says, he shall set him free in the place of his eye, and not in the place of both his eye and his tooth. And if you read the next line, it says, he shall set him free in place of his tooth, and not in place of both his eye and his tooth. So what it's saying is, according to the Ramban, Nachmanides, and Gittin, the 42nd Daf, that Abai isn't really expounding the verse to teach the law. What he's just saying is he's just emphasizing the pasuk to say that even the loss of one organ suffices to set a slave free. So obviously logic dictates that the minute the slave gains his emancipation, because it's a knas, it's a penalty, and it doesn't take effect until evidence of the injury is presented in court, and the court rules that he's free. But once the court rules so, becomes free retroactively from the time of the injury. So that's the reason that the master pays for the destruction of the second organ. And that was the point at which we learned. It's not at the point where the court says he's free, does he now basically lose the claim on the second organ, because it's only when he's free that if there's any new case that comes up, Kevin, he can sue the master as a free man. No, it's saying whatever was the initial physical blow that set the slave free, at that point he's free. Any other damages that are caused after that point, the master is entitled to pay for, because this person is no longer a slave. So that's retroactive damage paid. And that makes sense, because a buyer holds to retroactive disqualification of witnesses and also retroactive damage paid. So the buyer gave a pretty good explanation there.
So you just said the buyer, once the
buyer.
slave is free,
Yeah.
the master, if the master causes any physical damages to the body of the slave or to the organs, then he has to pay. Is that what you just said?
Now I said something slightly.
When he's not the master, when he's free, once
I
the
said
slave's
something
free.
slightly different, because as Rav Zari could have thought perhaps that only when the court determines that the slave is free. Any future damage another human being does to him, he's able to sue from that time period. And Rabbi is saying, no, from the time period at which he was hit, he's technically free. Therefore, if the master hit him somewhere else, at that point in time, from where he was free, not from the court stating he's free, he's liable for damages. That's what Abai is saying to Rav Zeri. Okay. All right, let's move on. Now that we've digressed, we've gone back to the main issue. Rav Idi Bar Avin said, we have learned so far in our Mishnah, if the fact that one stole an ox or a sheep, and covenant was established by the testimony of two witnesses, and the fact that he slaughtered or sold the stolen animal was established by the same set of witnesses as well, and they were found to be zomimim, conspiring witnesses, they paid this innocent person everything. In other words, a twofold and threefold. Okay? So, is not the Mishnah referring to a case where first they rendered testimony about the theft and then testified against this victim about the slaughter? Okay? In other words, they didn't testify about the theft and slaughter at the same time. They testified on Sunday that he stole and then testified on Monday that he slaughtered the animal. So that's Rashi's explanation, that that's not at two separate time periods. Now, if you look at Rav Idi Bar Ravin, he follows Rabba's view that Zomimim witnesses are disqualified only from the time they're exposed and from then on. Okay? But according to Abaya, there's retroactive disqualification. Okay, so we're going to get to our point now. So if they were subsequently rendered Zomimim with respect to their testimony on the theft, and then they were rendered Zomimim again with respect to the testimony on the slaughter, then the question is, in other words, on Tuesday they were rendered Zomimim for what they said on Sunday regarding the theft, and on Wednesday they were rendered Zomimim for what they said on Monday regarding the slaughter, according to Rashi. Now, in this case, they were exposed as Zomimim on their testimony regarding the theft. They've become contradicted on their own testimony regarding the slaughter. Why, Gavin?
Just repeat that. I actually lost concentration there. Just repeat that. I know, you can see I lost it. I'm a bit dopey. Just repeat it.
So what it's saying is, look, if they testified on Sunday about the slaughter, and then they testified on, if they testified on Sunday about the theft of the animal, on Monday about the slaughter of the animal, and then there are witnesses that come and said that they couldn't have been with viewing this theft because they were with these other witnesses in a different location, and when it came to the slaughter, they were also viewed by separate witnesses to say they couldn't have seen the slaughter either. So why would they have to pay everything? Because there's a problem. They're contradicting each other. In what way?
Well, why would they have to pay everything? What do you mean?
They were found to be on the theft and the slaughter.
On both, yeah. So both are a problem. I mean, these guys are lying on both sides. Yeah, all right.
Okay, well, the problem is if you prove to be false on the theft, how can you accuse somebody of slaughter? You could be slaughtered.
Yeah, you can't. Then the slaughter falls away because if there's no theft, then the slaughter is not a problem then.
Correct. So the Gemara is just saying that these witnesses were found to be contradicting themselves.
Yeah, that's exactly it.
By other witnesses. But the minute they were exposed as Zomimim on both counts, they shouldn't be liable for the slaughter part. But the Mishnah still teaches...
Because that's the initial one.
Correct. But nevertheless, the Mishnah teaches that when they're subsequently exposed as Zomimim on the slaughter, they pay for everything, including the extra threefold. They conspire to have the accused pay for the slaughter, as well as the twofold. So it says, and if it should enter your mind that contradiction is not at the beginning of Hazamah, and witnesses whose testimony was previously invalidated through contradiction by their own testimony later are not subject to Hazamah, why do they pay for being exposed as Zomamim on the slaughter? So what it's saying is, this is an argument for Rava. Because Rava is saying that a testimony regarding the slaughter was contradicted and invalidated on Tuesday, prior to them being exposed on Wednesday as Zomamim for the slaughter. So what it's saying is that if there's a contradiction, you've got to turn around and say, well, then you've got to count Hazamah at the beginning of the process, because they are supposedly cancelling each other out, because they can't pay for the slaughter if the theft never took place. So they should cancel each other out. But the fact that the Mishnah says they paid everything implies that you have to take contradiction at the beginning of Hazamah, which saying if they're lying about the theft and then lying about the slaughter, the reason why we make them pay about the slaughter is because we're saying that they're obligated from when they started lying. And that basically proves that the entire testimony was one of lies, and therefore they should pay everything. They shouldn't cancel.
Which one was exposed? Can I stop you for one? Which was exposed first, the slaughter or the
theft? The theft.
The theft. If the theft, it should cancel each other out. I'll battle with that a bit. I heard you.
Okay.
Carry on.
So a buyer would agree with you, because a buyer, a buyer would and wouldn't, but we'll go through that now. So what it's saying is that you have to say that Hazamah is at the beginning of the process, because otherwise you wouldn't have to pay for the slaughter. So the proof that Hazamah is the beginning of the process, according to Rava, is from the fact that the Mishnah says we pay everything. That's exactly the proof. So in other words, from the moment they're lying, that's included in their Hazamah to start to pay the reciprocal penalty. They don't get the benefit of cancelling each other out, because Hazamah is taken from the first point that they lied, not where they're lying about the first point and it disables their second point. So in other words, as Gavin said, that the slaughter and theft should contradict each other. So if they never stole the animal, if this guy never stole the animal, he can't be made to pay for the slaughter. So it should invalidate the slaughter case. But because Hazamah is taken not from the point of slaughter, but from the beginning of their testimony and theft, that's what did they intend to do to the victim? Make him pay 5 times. So therefore, the Hazamah is taken from the beginning of the incident and they make him pay 5 times. So that's a proof for Rava. Now, Gavin did bring a good point, because that's what the Gemara is saying, is that the Gemara rejects the proof exactly for Gavin's reason. If you want to say, you can quite easily say that the Zomamim on their testimony regarding the slaughter first, before they were exposed as being Zomamim on their testimony regarding the theft. So exactly that. So that if they exposed as the slaughter, then the court says they pay the threefold. Okay, and then once they paid the threefold, a few days later they were found as lying about the theft. So then they have to pay the twofold for lying about the theft, because the other matter's already been sorted out, because the slaughter came first. So that's pretty much in a nutshell. For example, witnesses came on Tuesday and then they rendered them Zomamim on the slaughter. And then other witnesses came on Wednesday and rendered them Zomamim on the theft. So at the time they became liable for the threefold payment for the slaughter on the Tuesday, their testimony regarding the theft, as Gavin said, remained intact and therefore valid. And then the accused would have had to have paid the twofold payment, because he wasn't seen, the Adam Zomamim were not seen lying about the theft part. So who ends up paying? The accused on the twofold payment. Therefore, when they rendered Zomamim on the theft on the Wednesday, they become liable to pay the twofold payment as well. So that brings their total liability to 5-fold, according to Rashi. Now, interestingly enough, a buyer that contradicts Rava, it says that contradiction begins at the beginning of Hazamah, can't be a case here, because if you look at it, is that according to, look, okay, let me put it like this. So the Gemara has concluded that according to a buyer that disputes Rava regarding contradiction being the beginning of Hazamah, So according to Abaya, which Gavin and I obviously gravitate towards in this case, we can see why Abaya says unless they were accused of slaughter, the guy was accused of slaughter first, the theft would destruct the portion of the slaughter fee, because he could only pay on the slaughter if it's his animal is slaughtering. So the Mishnah must be speaking of a case where witnesses were rendered on the slaughtering before being rendered as zomamim on the theft according to a buyer. Okay? But according to a buyer, it must be in this case where they had to testify to the theft and slaughter at the same time, because otherwise the conclusions are incompatible with the Mishnah. Because if you remember that if they testified about the theft and slaughter at one time, the retroactive disqualification on the slaughter would have the effect of invalidating their testimony within the term of an utterance. Gavin, do you remember, for the theft? Because if part of their testimony is invalidated, all their testimony is invalidated. So this only came up with the case of within an utterance. But what you've also got to bear in mind is, according to a buyer, you must say that they were exposed to zomamim on both the theft and slaughter at one time. So their testimony wasn't set aside. But apart from which, there's no problem with the buyer, because a buyer generally believes in retroactive disqualification of a witness in any event, which means even if they happened at two separate junctures, he's saying if they lied on the one, you take it all the way back and you basically can make them testimony invalid on everything else. Does that make sense? Yeah. So in other words, a buyer is just arguing with Rava on this point of Rava, but he doesn't even need to say that. He can just say that at the end of the day, it's not that Hazamah is at the beginning of contradiction. It's that there's a reciprocal penalty. The reciprocal penalty doesn't work in the case where there's retroactive disqualification on the witnesses. Because if they're lying about the slaughter, you can't trust their testimony regarding the theft, he's saying, either. And therefore, if they're lying about the slaughter, they pay the threefold, but they don't pay the twofold. The only way he could pay the twofold and explain the Mishnah is he's saying if it's within one utterance. Then in both cases, they've cooked their own goose. So therefore, they pay the reciprocal penalty. But on both the theft and the slaughter. But if they were two different testimony junctures, we invalidate their theft testimony so the accused doesn't have to pay for the theft, but we don't make them the Adam Zummerman paying the theft, because we just don't count that testimony as being valid. But we make them pay in the slaughter, because only at that point did witnesses say that they couldn't have viewed it on that separate day. It's not saying that they were lying about the theft, it's just their witnesses that couldn't testify. But we don't trust their testimony anyway, a buyer say. Okay. All right, guys, we're done.
Wow.